But Your Honor, the state would be offering state exhibit number 39 into evidence at this time.
I believe this was previously ruled on, Judge, outside the jury's presence, and we have no objections as it's being offered.
All right, then state's exhibit number 39 is admitted without objection.
And Your Honor, it's the waiver of consent to stipulation of testimony and stipulations stating that the defendant in this case, Vernon Dixon, was charged and convicted of the felony offense of possession of cocaine under 28 grams on July 20th, 1992, and cause number 1991 CR 0678 in the 187th District Court.
All right, and defense, you stipulated to state's exhibit number 39, correct?
We have, Judge. We've had a chance to review and everyone signed and we agree to stipulate.
All right, then state's exhibit number 39 is admitted.
Maybe I just publish it to the jury, Your Honor.
Yes. All right, state, call your next witness.
At this time, Your Honor, the state would rest.
All right, defense.
Your Honor, may we take up a motion outside the presence of the jury?
Yes.
Thank you.
All right. But ladies, we're off the record. Ladies and gentlemen, I'm anticipating, and both the state and the defense have told me that they expect both sides to be finished today. So even though you're doing back and forth, things are actually happening. So I'm going to have you all go to the back and I will call you back at 2:50. And remember my previous instructions. All right, everyone, please rise for the jurors.
Yes.
All right, everyone, please be seated. All right, and defense, you have motion?
Yes, Your Honor. At this time, it's my understanding the state has rested their case and the defense would respectfully move for an instruction of acquittal in this matter. To illustrate as to why we believe we are entitled to such, Judge, we point out that there is a shocking lack of physical evidence on this case.
Oh, you may remain seated.
Oh, if it's okay, the court, may I stay standing?
Sure.
Sorry, we've been sitting a lot today.
Okay.
Back's hurting me. Judge, there's been a lack of physical evidence on this case, and furthermore, I think a lot of confusion over testimony. And I believe the standard that we have to ask ourselves is, could any reasonable juror come to the conclusion that Mr. Dixon is guilty as to the offense of murder? And I believe that there has been insufficient evidence shown that a reasonable juror could jump to that conclusion, could reach that conclusion, Judge. Again, we've had testimony contravened per people saying that we were there. Defendant goes by the name of Juicy, said he didn't see any shooting. He's 15 feet away or so. People that hear gunshots but don't necessarily see a shooting going on. Again, a lot of assumptions, a lot of conclusions, but a serious lack of physical evidence, Judge. And we believe that all comes down to the fact that no reasonable juror could reach a verdict of guilty in this case. And respectfully, Your Honor, we would ask the court to instruct the jury to move for a verdict of acquittal in this matter.
Thank you. All right, state.
Your Honor, the state's position is we have proven every element of the crime, including count 1, count 2, and count 3 in this case, Your Honor. Eyewitness testimony, including security video footage of at least 2 different angles of the actual shooting or the scene that day, including other evidence, the raw evidence at the scene, and also the medical examiner, lab scientist testimony brings into the fact that the elements have been met, and this should be going to the jury for guilt or not guilt deliberations.
All right. Defense, is your motion. You have final argument.
No, Your Honor, we will rest on our previous argument as stated, Judge.
Judge, bottom line is real simple. You can look at the video and you can't tell who does the shooting. That's really the bottom line in terms of the facts that have to be determined by this jury.
Right, thank you. All right. Defense's motion is denied. Defense, are you calling any witnesses?
Your Honor, may we confer with our client just for a few minutes?
Sure.
Yeah. Actually, I'm going to step out with Mr. Schaefer and talk with somebody, and we'll be right back.
All right, of course. All right, everyone, please be seated. All right, the state has rested. Defense.
Your Honor, this time the defense would rest and close.
State, do you close as well?
Yes, Your Honor.
All right, you may be seated. Ladies and gentlemen, this is all of the testimony you're going to hear in this portion of the trial. So this is what I'm going to do. I'm going to give you your instructions, and these are your instructions. You are not allowed to start deliberating in your mind. Do not think about this case. When I release you, you're not allowed to deliberate with each other. You're not allowed to watch anything about this case. If you see something or hear something about this case, completely ignore it. My rules still apply that everything that you learn about this case is to come from inside the courtroom and nowhere else. Does everyone understand?
Yes.
All right. We can go off the record. So this is the order of things. Tomorrow, we're going to start at 9 a.m. Even though I have a docket, this case will go first. What will happen is I'll read to you the jury charge. You're not going to have to memorize that because you'll be given a copy of it. Then both the state and the defense will have a chance to give their closing arguments to you. Then after they've done that and you've selected a jury foreperson, that's when you will be allowed to begin your deliberations. Does everyone understand?
Yes.
Right. All right. You all know that the courtroom is slightly crowded. That's part of my docket today, but it has nothing to do with this trial. Does everyone understand? All right. I'm going to read to you what's called the jury charge, a charge of the court. You do not have to memorize it because you will be given it once you go back to the jury room. Members of the jury, the defendant, Vernon Dixon, stands charged in count 1 of the indictment with the offense of murder alleged to have been committed on or about the 31st day of March, 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 2 of the indictment with the offense of unlawful possession of a firearm alleged to have been committed on or about the 31st day of March, 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 3 of the indictment with the offense of tampering with physical evidence alleged to have been committed on or about the 31st day of March, 2022 in Bexar County, Texas. 1, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2, our law provides that a person who has been convicted of a felony commits the offense of unlawful possession of a firearm if he possesses a firearm after the 5th anniversary of the person's release from confinement following conviction of the felony, or the person's release from supervision under community supervision, parole, or mandatory supervision, whichever date is later, at any location other than the premises at which the person lives. The offense of possession of cocaine under 28 grams is a felony offense. 3, a person commits the offense of tampering with physical evidence if, knowing that an offense has been committed, the person conceals a thing with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation of or official proceeding related to the offense. The offense of aggravated assault with a deadly weapon is committed if a person intentionally or knowingly causes bodily injury to another while using or exhibiting a deadly weapon, or if a person intentionally or knowingly causes serious bodily injury to another. 4, individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Possess or possession means the actual care, custody, control, or management of property. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. 5, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, with respect to the evidence admitted in this case concerning the defendant having been previously convicted of a felony, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant was in possession of a firearm on or about the 31st day of March 2022. 7, count 1, murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, did intentionally or knowingly cause the death of an individual, namely Avante Boyce, by shooting Avante Boyce with a deadly weapon, namely a firearm, or the defendant, Vernon Dixon, with intent to cause serious bodily injury to an individual, namely Avante Boyce, did commit an act clearly dangerous to human life that caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm, then you will find the defendant, Vernon Dixon, guilty of the offense of murder as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 1. Count 2, unlawful possession of a firearm. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, having been convicted of the felony offense of possession of cocaine under 28 grams on the 20th day of July, 1992, and cause number 1991 CR 0678 in the 187th District Court of Bexar County, Texas, did intentionally or knowingly possess a firearm after the 5th anniversary of Vernon Dixon's release from confinement or release from supervision under community supervision, parole, or mandatory supervision following conviction of said felony at a location other than the premises at which Vernon Dixon lived, to wit, a public place, then you will find the defendant, Vernon Dixon, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 2. 9, count 3, tampering with physical evidence. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, knowing that an offense had been committed, to wit, aggravated assault with a deadly weapon, did intentionally or knowingly conceal a thing, to wit, a firearm, with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation or official proceeding related to the offense, then you will find the defendant, Vernon Dixon, guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 3. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You're instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet, chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict. If that can be done without violence to the individual judgment, a unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and jury forms are attached. State, are you prepared to proceed?
Yes, Your Honor. I very briefly wanted to cover a few things that are found in the jury charge. You're going to hear from the defense, and then you're going to hear from Jason one last time before we're done. So, as the judge mentioned, there are 3 counts of this case: murder, unlawful possession, and tampering with physical evidence. Now, each of these are independent of one another. So you have to consider, did the state prove the elements in each count independent of one another beyond a reasonable doubt? So let's start with count 1, murder, separated into 2 paragraphs. Now, what that means is that it's paragraph A and paragraph B. One juror could say that they found beyond a reasonable doubt paragraph A, and then the rest can all say paragraph B. It's just that it's unanimous that it's one or the other. So let's start with paragraph A. It's on or about March 31st of 2022, Vernon Dixon in Bexar County, Texas, intentionally caused the death of Avante Boyce by shooting him with a firearm. Now, there have been many witnesses who have come forward and said that those events happened. They've explained that through their testimony. And again, it's each individual part. It's the date, where, who, shooting, intentionally causing death by shooting a firearm, which is a deadly weapon. That's what everyone agreed on. So paragraph B, it's again, on or about March 31st of 2022, the defendant Vernon Dixon, with intent to cause serious bodily injury to Avante Boyce, committed an act that was clearly dangerous to human life, shooting a firearm at Avante that caused his death. Now again, it's not that he intended to kill, it's that he intended to cause serious bodily injury. How do we know that? He shot at him with a gun. You are intending to cause serious bodily injury when you do that. And it's clearly dangerous to human life because you can't say what that bullet's going to do to a body once it hits. So then moving on to count 2, it's unlawful possession of a firearm. So the defense in States 39 stipulated that the defendant was convicted in, it was 1992 CR 0678. So that's already been stipulated to, that he was convicted. Now it's looking at, did he possess a firearm? Many witnesses came and said he was the one who had the gun. Next, was it in a public place? Well, he didn't live at that apartment complex. He had access to it. Several people had access to that apartment complex and that patio area. So it was a public place. Then the next one, it's count 3. It's tampering with physical evidence. Now, a witness came and said it was Donald Neely. He said that after the shooting, Vernon handed him the firearm, and that's why the firearm wasn't found. He handed it off with the intent so that it couldn't be found. When you hand it off to someone, you're not saying get rid of it. Now, again, each of these are independent of one another. It's, did the state prove each count beyond a reasonable doubt? Now, you aren't going to get any of the police reports that have been referenced to by several of the witnesses. That's not going back there. You can't let bias or sympathy play a role in your determination today. The question you have to answer is, for each count, did the state prove these elements beyond a reasonable doubt? We have. We brought many witnesses to say what happened that day and how Avante lost his life. We have proven on each count that he is guilty. Thank you. And state reserves all the time. Thank you.
All right, defense.
Yes, Your Honor. May it please the court, counsel for the prosecution. Good morning. How are y'all today? The first thing I want to say is the charge of the court. I'll remind you that goes with you to the jury room. So don't worry about trying to remember what we said, what like that. It's all in here. The judge has the law. The lawyers have their duties. The state wants to convict Vernon Dixon. Okay, they want you to find him guilty. Remember that what we talk about here, we lawyers, is not evidence. Okay, evidence is that which the court admitted from the witness stand. We all have our views, we all have our opinions, but what we say is not the evidence in this case. The real bottom line here is, what does the evidence say? Okay, what does the evidence say? The state produced a video in this case, and you have to look at the video. And the state has alleged that the murder occurred at 3 o'clock with 49 minutes and 41 seconds. Look at the video, because some of the witnesses said, oh, he did it. And some of the witnesses say, we don't know who did it. What's that? That's a reasonable doubt. That means that the state has not proven this case beyond a reasonable doubt, as they are required to by law. The video. Some of you think maybe he did it. And some of you are wondering, did he do it? That right itself, that in and of itself creates a reasonable doubt. If you don't know who did this, then you must find him not guilty. I've looked at the video. Y'all have looked at the video. Look at the video again, and in your own mind, decide, do I see Vernon Dixon shooting the gun and causing the unfortunate death of Avante Boyce? I can't tell you that. You have to decide the facts in this case. The bottom line is, you have to decide the facts and you have to decide maybe he did it. Maybe he didn't. What we don't know is that there's at least half a dozen people there present. We don't know who shot Avante Boyce. And if we don't know it, you don't either. That, ladies and gentlemen, is the reasonable doubt that you have to go back to the jury room and make your own mind up. I'll remind you of some of the instructions in the charge. Each of you has to make up your own mind. I don't want you to say, well, I'm going to go with the rest of the jurors because I'm in the minority and they're a majority. Each of you has to make up your own mind. We want to go ahead and thank you for your service in this case. We want to thank you for your verdict. We look forward to hearing back from you.
May it please the court, state. Good morning, ladies and gentlemen, and thank you all for being here. It's been a long, I think this whole thing started about a week ago, and we understand that this was not an easy sacrifice for anyone, but without you, this whole process can't happen. We're here today, state of Texas versus Vernon Dixon. Mr. Schaefer told you is correct. Burden of proof in a case. The burden of proof is always on the state to prove, and they must prove each and every element of every offense. If you have reasonable doubt as to anything, any of the elements, whether this happened in Bexar County, a date, any of the elements in there, then you must return a verdict of not guilty. And that goes for all three counts of murder, felon possession of a firearm, and tampering with evidence. Remember, we talked about in Verdire levels. We have reasonable suspicion on the very far end. That's enough for a traffic stop. Beyond that, we have probable cause, which is burden to arrest. And that's less than 50%. Beyond that, we have preponderance of the evidence, which is just a little bit more than 50%. Beyond that, clear and convincing evidence, which is, excuse me, you see this in a CPS case, Child Protective Services. It's enough to remove a child from a parent's home and place them with a new family. And then beyond that, we don't know exactly where this level is. We leave it to each and every juror to decide for themselves, is beyond a reasonable doubt. It is the highest burden that we have, and it's the highest for a reason. Because what you're deciding here today is life or liberty for somebody. This is the only kind of offense, criminal offenses, that can result in somebody being thrown in prison, thrown in jail. And for that reason, our laws say that you must be convinced beyond a reasonable doubt. What is presumption of innocence? I think we told you at the beginning, it's the only presumption that carries through a verdict, through a jury trial, all the way until a verdict is rendered. As he sits there today, Vernon Dixon is presumed innocent. And I'm going to suggest to you that the state failed in their burden to prove beyond a reasonable doubt that he is guilty of any of the offenses today. And why is it important? It's because it's the only presumption we have in a criminal case. It's what protects us all. Again, we talked about three possibilities: guilty. That's an analogy. You have a horse race and it's a runaway. You have guilty, not guilty, and then you have this last one, not sure. You look here, you remember, it's like a horse race in the moment, kind of hard to tell, somebody won by a nose. If you are unsure, if you're left there with a doubt, that is your doubt. That is your reasonable doubt. And not sure is not guilty. I'm going to talk about what you have. You have a blurry video, and Mr. Schaefer mentioned it. Go back and watch the video. It's admitted in evidence. You can watch both of them. Take a look at it frame by frame if you want and see. You do not see the shooting on that video. You cannot tell who killed Avante Boyce that day. And uncertainty is reasonable doubt. I think I told you in opening that this is a case of missing pieces. The state is going to present evidence, but they're also going to have a lack of evidence. In this case, we have no fingerprints, no weapon, no GSR. Do you remember GSR? We had, I think, 3 witnesses talk about it. Gunshot residue. You remember what Dr. Kanan said? Said that at a close quarter shot, something that happens so close range, you should see GSR on the burn wound. Even at a close range, it should be there. And you'll have the photos. It was not there. So does this match up with the state's theory that Vernon Dixon in close quarter shot and killed Avante Boyce? I'm going to tell you it does not. Again, you had multiple people under that pavilion, multiple people that could have been the shooter. Talk about witnesses. You had Versa Austin, aka Juicy. The state had him on the stand for a long time. At one point, they were arguing with him. He's about 15, 20 feet away from the car. He says very clearly, I did not see who shot him. And he's there with the perfect vantage point. You have Mr. Carl Cunningham. He said he saw something, but he's across the parking lot. You remember the photo that he presented. That's also an evidence to you guys. He sees something going on. He hears a shot, but does he have a clear view of what actually happened? And my suggestion to you is no, he does not. Donald Neely goes by Raymond. Said Vernon handed off the weapon to him, yet he's remained silent about this for over a year. He says something along the effects of, I didn't think it was important. No one ever asked me. Well, does that make a whole lot of sense? If you had something as important evidence, he admitted, yeah, I knew there was a shooting. Yeah, I knew something went on. Oh, by the way, this happened, but I didn't bother telling anyone about this until just a week ago. Why does that make any sense? And the answer is it doesn't. As for motives, we don't know. The state's not required to prove motive, nor is the defense. And lastly, we talked about Dr. Rajesh. Come on. Said 2 wounds, 1 fatal. We're not questioning the cause of death here. This was a gunshot wound that killed Avante Boyce. However, what was missing? No powder burns on the skin, which again, even through clothing at a close range with a firearm, 2 shots you should have seen, and we did not see it. This refutes the state's theory that this was a close range shot. And does this match up with the video? Someone as close as Vernon could not have made that shot. However, there's other people in the pavilion in that instant that very well could have been the shooter. Think about just the overall mood that day. There's high flying emotions and anger, and that makes for questionable testimony. We're going to come back to that. You heard that there's a fight. The girls are all fighting. And who's trying to break up the fight? You have Vernon, you have Avante, and they're breaking this whole match up. Everyone's in the car. Things seem to be cooling off. And then for seemingly no reason, they want you to believe that Vernon gets out and shoots and kills Avante in cold blood. Ladies and gentlemen, that doesn't make sense, right? We're going to tell you, don't leave your common sense at the door here. Nothing about this murder, about the offense here, the way the state is presented, matches up to the evidence or makes sense it just doesn't pass the smell test. And remember, uncertainty leads to reasonable doubt, and reasonable doubt must lead to an acquittal. I think I told you at the beginning, this is a case of what's missing, and what's missing in this is absolutely crucial, right? You have bits and pieces of a puzzle, but you don't have the full puzzle. And you cannot convict, you cannot follow your oath and convict Vernon Dixon based on only partial picture, not in this case. We're going to ask you to return the only verdict which makes sense, and that is not guilty. I just want to talk to you a little bit more. Like I said, you've heard from a total of 15 or 16 witnesses in this case, and yet you're left, in my opinion, we're left with more questions than we have answers. We have a lot of questions left on this case. And again, we told you certain facts are not in dispute. Avante Boyce is dead, and that is a tragedy. No one ever deserves to lose their life. You heard from E.B. Lewis, and it was the first or third witness that was called after 2 officers. She testified there's a fight, only 2 people trying to break it up. And again, does this make any sense at all? That somebody just randomly gets out and shoots and kills a person that just moments before they were working with? Or does it make sense that possibly there's a shooting, someone else is a shooter, and you just kind of jump to a conclusion? You make an assumption, yeah, this is the person that shot him. Think about Evie's vantage point. Back seat, Vernon's up by the front of the car. I'm going to suggest to you that she heard a shot, your brain puts 2 and 2 together, and it just doesn't match up. We talked about Versa Austin. He's standing there 15, 20 feet away. They had him on stand a long time. At the end, he had to say the same thing. Vernon did not shoot. He did not see Vernon shoot. And that's important. He's an eyewitness. He's right there. And he has the vantage point to see. And he's telling me that he was unable to identify him. Again, when you have inconsistent testimony, you have questionable testimony, it leads to doubt. And that's what you must infer and reach reasonable doubt in this case. And that is what we have. And that's what I told you at the beginning. That's what I'll tell you now. The state has failed to meet their burden. You may think, again, you can be 50%, even 60, possibly 70% sure we think this happened. But reasonable doubt is all that matters. And I'm going to tell you, I don't think the state has reached their burden. They have not proven this case beyond a reasonable doubt. Emily Dixon, she was on the stand. again, motions are high, kind of combative, but her answer was plain and simple. She did not see the shooting herself. And then we come back, we talked about Dr. Rajesh Khanna. He testified homicide by shooting, however, no GSR. And again, we cannot stress to you how important that is. Close range shot. Based on the video, they're saying that they're in close proximity, mere feet away, possibly just a foot or less. You should have seen GSR transferred, and yet you don't see it. And again, why is that important? It's because it does not match up with the state's theory of the case. It leads to reasonable doubt. And ladies and gentlemen, it leads to the only verdict that we think you can legally and justly return, and that is a verdict of not guilty. Once again, thank you very much for your time, your patience, and your consideration throughout this whole process. You've been great jurors, and we appreciate your sacrifice for being here. No, Mr. Garahan's going to speak with y'all. Again, thank you. We'll thank you for your verdict and respect your verdict. Have a good day.
Yeah, Your Honor.
Yes.
Defense counsel.
Counsel.
Ladies and gentlemen, I'll be the last one to talk to y'all today. And then you will go back to the back and deliberate on this case. And I'm going to briefly go through some PowerPoint because apparently that's what all these lawyers do now. So I felt that I need to do this. And let me make sure I got it. Okay. Elements of the crime. Daniel's already gone over this and y'all have seen this many times, but I just wanted to reiterate these elements. The date is not in question. Bexar County, Texas. You heard officer testify to that. Defendant has been named in this case. Intentionally knowingly, that's up to you. But the fact is, I think beyond a reasonable doubt, we met that burden many times over in this case. Causes of death. We have that victim, Avante Boys. We have that already. The fact is that it was done by a shooting, and as defense counsel said, it was done with a firearm. A shooting, and it's a deadly weapon. That's paragraph A. Paragraph B, if you feel that's appropriate, that's fine. Act clearly dangerous to human life. Shooting at somebody that's sitting in a car. That's act clearly dangerous to human life. I'm going to go on to count 2, unlawful possession of a firearm. Again, date, Bexar County, Texas. The defendant, that's not in question. Possession of the firearm. Again, that's part of the elements that we have to prove for this count 2. Without a question, he's been possessed of a firearm. Many witnesses already testified to that. Many witnesses, 4 to be exact. After a felony conviction, which defense has already stipulated that he has a felony conviction that's passed, you'll see that felony conviction, the judgment, that it's been over 5 years since he's been off for parole or community supervision or imprisonment. So the fact is, it's already after that 5th anniversary release from confinement or probation. So that's not a question. It's a public place. This is a parking lot. He is not to be possessing a firearm for the rest of his life anywhere other than his own home. In this case, it was in a public place, which is a parking lot of that common area. Tampering with evidence, again, the first part's already established, but knowing an offense had occurred, he knew an offense had occurred. At least at that point, he knew an aggravated assault with a deadly weapon had occurred because he has shot at another individual with that deadly weapon. That is an aggravated assault with a deadly weapon. That's a felony. Intentionally and knowingly concealed this thing, the firearm, which he did. I mean, you had testimony that he had from 2 different individuals that he handed the gun off to somebody else. You've seen it in the movies. Why do you hand a gun off? You get rid of it. Get rid of the evidence. What are you going to do if something happens? Somebody gets shot. You get rid of the evidence. That's what he was doing. He was tampering with this evidence. So again, count 3 is not even in question in this case. So again, I think defense counsel said it, and I said it during board hire. Don't check your common sense in at the doorsteps of this courthouse. It's common sense. Use your reasonableness to get that beyond a reasonable doubt. In this case, the state's confident that this is beyond a reasonable doubt. There's not a question of who killed Avante Boyce. It's not a question. Your common sense tells you that. Your common sense tells you this man over here sitting is the one that pulled that trigger that day. And how do we know that? Let's talk about the evidence in this case. Testimony of witnesses. Not one lay witness, meaning a person that's not law enforcement or the ME's office or CSI. Not 1, not 2, not 3, but 7 different witnesses on this case came in. 1, 2, 3, 4 are related to the defendant. His own family came in. Call her Evie Lewis. His stepdaughter. Person that he considered his stepdaughter. Came in, testified. Who is Avante Boyce to you? She said, I consider that my husband. We have children together. I was pregnant at that time. I had my second one after he died. But what do you consider the defendant in this case? That's my dad. Known him since I was 7 or 8. And she points the finger at this individual. Within feet of her child in the back seat with her, this man here takes a gun and shoots Avante Boyce while he's sitting in the front of that vehicle trying to get out from this man. And he knows he did it because the fact is he was there in that white jumpsuit. He knows that. The fact is, you know that. His stepdaughter knew it. And that little boy in the back seat with her, Avante Boyce's son, was within feet of his father being killed by that man over there. She testified to that. Now let's go to unique, or I'm unique. Biological daughter of the defendant came in and testified. Raise your hand, Dad. That's him right there. Yeah, she was angry. She didn't want to be here. We had to drag her in, but we brought her to you. And yeah, she was not the most hospitable. She was a little hostile at times, right? But one thing that came out was the truth. Saw my dad with a gun coming around. He had that gun. He was mad at me, pushing me when we were arguing with his stepdaughter. That, by all accounts, she doesn't lie. That's fine. But she came in and testified, Dad had a gun. You'll see on that video, and you'll see that still photos of that video, that she's on this side of the car. So yeah, maybe she did not hear what happened. See what happened, but she dang well heard it. And as soon as that happened, who came around that car? Vernon Dixon, with a gun in his hand. Go on to Donald Neely, her husband. What did you hear him say? When Vernon Dixon came around that car, he said, look what you made me do. I want you to remember that phrase. Look what you made me do. He said he handed the gun off to him. He was scared. He's the son-in-law of this man over here. The son-in-law, another family member. Go to Pearl Barnes. She was there at that scene. You look at that video. Pearl saw everything that happened. But who is going to come in and testify against their own child? That's his mom. I understand that. You understand that. She was there. She was watching. She saw him. She took him from the scene. She said, why'd you do this? Remember that. Carl says that. Heard a woman's voice coming from that car as it sped out of the parking lot. Why'd you do this? Plain and simple. That's his mom. Go on to Versa Austin, aka Mr. Juicy. It's homeboy, right? Who's going to testify against their homeboy? Juicy was certainly not going to testify against his homeboy. We all know that. He looked down the whole time, didn't want to look, make eye contact, was not cooperative. The judge informed him to answer the question several times. Last question I asked him, are you scared? Yeah, he's scared. He has to go back and live over there. He has to walk around those streets. Yeah, he's scared. Go on to Carl Cunningham. Independent witness. Just a maintenance guy. Took that picture of this individual over there in that white tracksuit. Very identifiable, might add, the white tracksuit. He's testified that that was Keno, knew him as Vernon King, and then that last phrase, he said Vernon King Dixon. Saw him with a gun, saw him shooting that car, saw him come around and hand that gun off, get in that car and take off with his mama, and heard her say, "Why did you do this?" Belinda voice brings in something very interesting, a voicemail. What I call the butt dial in this case. Let's talk about that, the additional evidence, but I'm going to skip to the voicemail. The voicemail. What was said on that voicemail? You can't hear a lot. It's a little mumble jumbled. I mean, if anything, you need to listen to that again. But one thing you will listen and hear on that, something that sort of goes with what Donald Neely said. On that voicemail, you will hear, they made me do it. What did Donald Neely say that the defendant said when he came around that car? Look what you made me do. Listen to that voicemail. It says that. We already heard from Evie that that person is Vernon Dixon saying that. That corroborates between Donald Neely, what he testified to, and that voicemail. That's a match. Another match in this particular case is Carl saying that that gun was handed off to who? Donald Neely. Why would he make that up? That leaves credit to Donald Neely of what he said. You look at these pieces of evidence that come in, those puzzle pieces, and they're falling into place. Clear cut. It's beyond a reasonable doubt. It shows that those puzzle pieces make a very clear picture. The security video in this case, without question, hey, I would love to have a video of every murder that I ever tried, or for that matter, any murder that ever happened. That would be great. But this is not a perfect world. This is not a perfect scene. The fact is, we don't have the actual shooting, the smoking gun in his hand. But you got testimony that's credible, that you match it up with another puzzle piece, which is the videos on two different angles. And it's very clear. It's beyond a reasonable doubt.
5 minutes.
Thank you, Your Honor. The white tracksuit, which I really, in this case, seals his fate. So identifiable from across the parking lot. Yes, there might be a tree in Carl Cunningham's photo, but what you can see clearly through that tree and those leaves is a white tracksuit standing there with his arm up. It's clear as day. Talking about GSR in the defendant's vehicle, there's GSR on the headliner and GSR on that seat where Avante Boyce was killed. No GSR was ever found on his hands, meaning that he most likely did not possess a gun or anything. And in this case, there's been no evidence that Avante Boyce did anything except for try to stop a physical altercation between females at the scene and got shot by this man senselessly. Bullets that were found in Avante Boyce came from the same revolver handgun. You heard the doctor in this case testify to that. You heard the lab technician scientist come in and testify to that. Both shots came from the same gun. The defendant fled from the scene with his mom. It's not a question. And then he fled to Kansas. You can use that as guilt against this individual. If you flee a scene after you shot someone, you're guilty of murder. In this case, he's guilty of murder. You're going to see in that video, if you need to watch it again, but you've seen it several times, but there's several different clips. I put still video photos in so you can look at the times on those still videos or photos and be able to match up for the video. But you've seen the video several times. Mom arriving. Defendant in that white tracksuit identified. That white tracksuit again. You see it from across the whole parking lot, that white tracksuit. Again, photo by Carl. White tracksuit. You see the defendant, at moments after the shooting, the defendant's on the other side of that car. I put two yellow circles on this in particular. If you look at this, the circle to your left, all the way to the left. You know who that is? Mr. Juicy. Because what did Mr. Juicy say? One thing that he said over and over and over, if I hear gunshots, I'm running. I'm out. He's all the way across the parking lot. Gunshots have happened. Victim is laying outside that open car door, and the defendant is coming around with that gun in his hand, and everybody else is standing there. And I don't know if you can see this, but I'm looking up there and I see Miss Pearl right there in the middle, leaning up against that picnic table. Because if you watch the video, Pearl walks to that car. She identified herself. She saw the whole incident. Right after, the defendant handing off the gun, circled in yellow there, to Donald Neely. Pearl and the defendant leaving that white tracksuit to get into that car. And if you did catch this video right here, the still shot shows that white tracksuit. And again, there's that white tracksuit following him throughout this case. Him pointing to his mom to take a right. The puzzle pieces equal a clear picture, and it points in one direction, only one. It's that direction right there. Vernon Dixon shot Avante Boyce for no damn good reason. It's senseless. It was stupid. And yeah, it doesn't make sense. But use your common sense and your reasonableness in this case. The defendant is guilty of murder on count 1, unlawful possession of a firearm on count 2, and tampering with evidence on count 3. Plain and simple. Vernon Dixon is guilty of murder, and hold him accountable, please. Thank you.
All right, ladies and gentlemen, you have heard all the evidence that you're going to hear in this part of the trial. So I'm going to send you back to the jury room. But before I send you back, if I could have Miss English and Miss Priest, please remain. All right, we're going to go on the record. In 2022 CR 9807, State of Texas versus Vernon Dixon, the court has received the following question from the jurors. Do we all have to agree on A or B in count 1? Have both parties had a chance to review the question, State?
Yes, Your Honor.
Defense?
Yes, Your Honor, we have.
And the court is proposing the following supplemental charge. Members of the jury, with reference to your inquiry as instructed in the court's charge, you're instructed that your verdict on count 1 must be unanimous. All 12 of you must agree beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, Vernon Dixon either intentionally or knowingly caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm, or Vernon Dixon with intent to cause serious bodily injury to Avante Boyce did commit an act clearly dangerous to human life that caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm. Please continue your deliberations. Any objection, State?
No, Your Honor.
Defense?
No, Your Honor.
Any objection to having the deputy take the supplemental charge back to the jurors, or would you like them to be brought out in the courtroom?
We have no objection to the deputy taking the supplemental charge to the jurors and back.
All right, thank you.
Thank you, Your Honor.